Well, let's get this started. Good morning and welcome to all of our attendees and to our panelists this morning. This is the third installment in our series, and today we're going to explore some frequently asked questions as respects managing existing workers' compensation claims during this new COVID environment. So I am Joe DeLucchi. I run an insurance firm by the name of Cal Insurance, headquartered here in San Francisco. And I am joined by our partners at ESM. I'll introduce Sharon in a moment. But I think we're all very aware, painfully aware at this point, that COVID-19 has been a major discussion point, particularly in these last 5 weeks. And as such, Cal and our key strategic workers' comp safety and claim management partner, ESM, have been inundated with emails and phone calls as respects various workers' compensation situations. And because of the volume of inquiries, we thought it would be important to host this particular webinar for our clients and for our referral partners and for our friends this morning. This webinar is also being recorded and will be posted on the Cal blog, so our Cal website, www.mycalteam.com, and that'll be up in the next day or two in case you'd like to review it again or share with others. So Sinead, let's go to slide number 2. Okay, so in the interest of keeping the talk moving along today, everybody's going to be on mute, but we know that you're going to have some questions. And if you scroll down to the bottom of your screen, you're going to see a Q&A button. And with that, you can post your questions. They'll be compiled and they will be asked and answered. We're figuring many folks probably are going to have questions that are similar in nature, and that's why we're asking you to type it into the Q&A box below. And as we can just go over very quick here, there's going to be 4 elements to the conversation today. So number 1, this is a workers' compensation focused seminar. Number 2, we just talked about, we're going to ask questions in the Q&A button below. I don't know, Sinead, are we able to raise hands as well? I think we have that off for today, but we will follow up with the Q&A after. So if we can go to slide number 3, let's get this started. Okay, so Cal decided to partner with ESM for our clients' workers' comp claim and safety management about a year ago. And it's just been a wonderful strategic and key partnership. Our clients have really benefited greatly from the expertise that Sharon and her team have in guiding folks through a complicated, what can be a very complicated workers' compensation system. So at this point, I really would like to introduce Sharon Poston, who is the president of ESM, and Sharon, will be the moderator today. And Sharon, I'll ask that you introduce your team of experts.
Okay, thank you, Joe, very much, and thank you everyone for joining us. A couple of weeks ago, we were having a staff meeting and really just collaborating, brainstorming, talking about all of the questions that we were receiving from our clients and coming up with answers. And I said, wait a minute, this sounds like a perfect example of what we can share with all of our clients, because we have a combined total of about 75 years of workers' comp claims experience. So why not share what we are talking about and learning from this experience with all of our clients? So I want to introduce to you a few people. Sinead Scrisopi, excuse me, customer success. Hi, Sinead. She's running the technical part behind the webinar today. Thank you very much for that. We have Abe Jabhan, Senior Claims Advocate. He's in our New York office. We didn't know we had a New York office, but thanks for joining us. Let's see, Kai Sim is in front of the Golden Gate Bridge. Thanks, Kai, for joining us. Saul Pazar, also. I'm sorry Haley had a conflict this morning. I know many of you work directly with Haley, but she is available in the future, and she's always available to you by phone if you have any other questions. Okay, the last 2, before we get into the questions, the last 2 webinars that we created and really was a response to all of the questions that we were getting was one talking about the focus of how are we dealing with the COVID infectious disease part of Cal OSHA's requirements. So we talked a little bit about that. And then we had another one about work from home protocols. So today the focus is shifting a little bit. And we're just going to be talking about workers' compensation claims, existing claims. So what has happened, the Workers' Compensation Insurance Rating Bureau is reporting that there are fewer claims statewide right now because we have fewer people working. So we felt like this was an opportunity to bring together all of the information that we have, and maybe this is a time that we can resolve any disputes and settle any claims that we've had going on. So we came up with 6 questions that were kind of the common questions, and we'll address those in the next few minutes. And then at the end, we'll open the floor to you. So if we don't answer your questions in these 6 that have been the most common that we've been receiving, then you can add your own. And as Joe said, you just type it into the chat screen and one of us will answer that at the very end. Okay, now we're ready to start, Sinead. Our first question is, what is telehealth or telemedicine? And how can that help our business during the COVID-19 order to stay home? So we're going to have Saul address this one. Go ahead, Saul. Thanks.
Sure. So telemedicine uses technology to provide services to patients instead of having an in-person appointment. So the physician meets with the patient via video conferencing technology, and they perform an evaluation. This is important because per labor code, the patient needs to be seen every 45 days, at least every 45 days, and be given a work status. So this is a way to be able to have continuity of care, and that that is met, the work status requirement is met, especially during the stay-at-home order that we have currently. Not all providers provide this service, so just make sure you reach out to your clinic, occupational medicine clinic, to make sure and find out whether they provide the service or not. Also, we just found out, and things are coming in and out, information's coming in daily, but the California does have a fee schedule for teleconference or telemedicine now, and I believe it's the same as Medicare, and it's actually cheaper than an actual visit. So that's the pro of that. So it's a good source to have, and if we are worried about continuity of medical care, it's a good way to see if we can have that through the physician's office.
Oh, great. I mean, telemedicine has been around for a while, but there's been a little hesitancy to participate. And I really see this as an opportunity to encourage employees who have that need or that opportunity. I mean, sometimes you need a physical exam so that the doctor can actually see you and touch you. But in many cases, it can be a follow-up via the telephone. And I think this may be a change in the way that we handle things going forward, which would really be a time saver. You don't have to drive to the office. You don't have to take the time to sit there to be seen. And as Saul mentioned, this was an article this morning on Work Comp Central. The Division of Workers' Comp has added a code for the fee schedule, because in the past, the fee to the physician was less than the visit, and less than what Medicare was paying. So I think this is a good move. Still, as Saul said, still less than a physical visit exam, but now the doctors will be compensated for the time that they spend with the patient. So yes, that's a positive thing.
And I think you have a good point, Sharon. This is not a cure-all, right? We are not going to shift from in-person visits to telemedicine completely, because telemedicine will never replace an actual physical appointment, especially when it's an initial evaluation. After surgery, you cannot test range of motion through telemedicine. It's just not possible. So it will not be a replacement, but it's a good substitute for now, given our current conditions, given the current stay-at-home order. It's a good substitute to have, and to be able to make sure that the patient's still getting the treatment and the care from the physician.
Oh, great.
And one of the things that I wanted to add is, especially physical therapy, now you're seeing more and more where they're offering rehab via video. So that's an option for those employees that are currently in PT, especially if they have been to 1 or 2 visits, then they can probably do the remaining visit via video. Also, if they're not improving with the telemedicine, the doctor can still order diagnostic. And so sometimes it does take, a couple of weeks before the carrier will authorize it. So that at least gives some time so it gets started. Let's say if your employee needs an MRI, at least the claims administrator can start looking at it, send it through UR. So hopefully by the time this is all over, they have that schedule, and then their medical is moving forward versus having to wait a couple of weeks and start that process.
Yeah, that's a good point. I agree with you. About 10 years ago, I had a frozen shoulder and I tried everything. Of course, it got better because I intended for it to get better. But I went to physical therapy one time and they gave me a list of exercises and he showed me, the physical therapist showed me one of the exercises. And then I really pretty much was on my own. And I thought, well, I can do this at home. I've got the list of exercises. I know what to do. And so I continued to do my physical therapy at home. And for some people that will work. Others need the supervision and need somebody there to coach them and guide them. But there are many people who are able and will continue their physical therapy on their own. So I think this is a good alternative. Okay, Sinead, let's look at the next question. My employee is currently off work after a March surgery for a knee injury. He is recovering, but his surgeon just rescheduled his April appointment to sometime in May. I'm worried about his temporary disability benefits being stopped. What can he do to get the necessary medical authorization for continuing TD? Saul, let's take this one, please.
So this is a good example where telemedicine can be helpful, right? This person just had a surgery in March. Now we're in April. His April appointment was postponed to May given the stay-at-home order. So this is a good example where the patient, the employee, can call the doctor's office and see if they can provide telemedicine, and if we can meet with that doctor telemedicine and has this appointment as previously scheduled in April as opposed to May. Not all offices provide telemedicine, so it might not be an option for this employee if the provider does not have that service, but it's something that they should try to make sure that the work status is provided and the 45-day requirement is met. If the specialist does not offer telemedicine, they can go back to the original doctor, the occupational medicine doctor, and ask if they offer that service. Because given the circumstances, that doctor can provide the work status and still be an actual certified work status where he can still be provided temporary disability. If by any chance nobody can see him via telemedicine and there's no way to get him an appointment until May, just talk to the examiner. This person had a surgery in March. It's a knee surgery. Given in my experience, I know that a knee surgery typically takes between 3 to 6 months before we see any sort of release, hopefully 3 months for a modified duty release at least, but we are 1 month out. So more than likely this person is gonna be temporary disability. Just talk to the examiner, advocate for the employee. They shouldn't be cutting off TD. They do have the right to cut off TD, but if you think of this logically, they shouldn't. And we've found out is that most of the carriers are being pretty understandable of what's going on now and are a little bit more relaxed about the 45-day rule. So just talk to the examiner to make sure that conversation is had and that the employee has a peace of mind to know that, hey, even though I didn't go to the doctor, I will still continue to have my temporary disability payments. And avoid litigation. They're staying at home looking at those TV commercials. So we want to make sure that we do have the communication between the employee, the examiner, and yourself to make sure that whatever happens, on this particular case, temporary disability is not cut.
So are you hearing from the key occupational clinics, are most of them providing telemedicine?
I know for a fact that Kaiser is, and Kaiser's the Kaiser at the Job, that's the occupational medicine part of Kaiser, and they are. You do have to call in to schedule the appointment. If you already have you on record, it's pretty easy for you to arrange that. I think they want to make sure that the employee, the patient, has the right equipment for the appointment, because in order to be met as a telemedicine appointment, you have to make sure that this video available both ways, meaning they can see you and you can see them. So it's a key part of telemedicine. So they want to make sure that the patient has the availability and capability of doing that.
Okay, great. Very good. Any other comments, anyone?
I think, for those clinics or doctors that are not doing video calls or meetings with their patient, and they're off of work, as Saul mentioned, because of, let's say, their status post-surgery a couple weeks, it's really important to make sure that they have a date on calendar with the provider, because that way the carrier will not terminate TD as long as there's a date on calendar. Because if there's no date on calendar for the next follow-up appointment, what carriers will probably do is they'll issue a TTD delay notice. They'll terminate well, I shouldn't say they're not going to terminate but they will delay that disability payments if there's no appointment on calendar. So just make sure that there's an appointment on calendar,
Great.
even if it's 45 days out.
Great. Very good. Okay, let's go to the next question. So this is a person who did not have to shut down completely, and this question was, my working employee has a minor elbow strain from lifting, but she doesn't want to go to the doctor during this COVID-19 exposure. What can I do? Abe, will you take this one?
Yeah, sure. Well, I always recommend giving an employee that's alleging a work-related injury a DWC-1. I know Joe has been with us on the work from home webinar that we gave, and there's additional exposures now that people are working from home, but the same applies. There's still workers' compensation exposure. If they don't want to treat in person, which is understandable during the COVID-19 pandemic, the employer, as Saul mentioned, can provide potential telemedicine options, loop in the carrier to discuss scheduling. That comes with the same caveat as before. Not every type of injury can be evaluated via telemedicine, but it is an option, and it's something that you can reach out to the carrier to see what those options are.
Abe, my sense is that most of the adjusters are being reasonable with accommodations right now.
Oh yeah.
Is that your sense as well?
Yeah, absolutely. And everyone seems to be a little bit more flexible. Employers are being more flexible about how they're handling their employees. In this particular case, if they don't want to treat at all, I would just have them sign a medical declination form. That way, you're showing that you're offering the treatment. You've given them the DWC-1. But yeah, I think you're right, Joe. Carriers have been a lot more flexible.
And the biggest takeaway here really is to just make sure, again, we can't iterate this enough or reiterate this enough, is if an employee, does allege a workplace injury, that we get those 2 workers' compensation forms into the insurance carrier straight away.
Joe, and sorry, really quickly to your point, you're definitely right that most of the carriers examiners are being reasonable, but there's always that one who's a stickler for rules. So
right.
We just want to make sure that you do communicate with the examiner, let them know what's going on, and so that way you also know what to expect in terms of benefits, medical care, whatever it may be, because what if you have that one examiner who's a stickler for rules and you need to work on that or persuade him.
That's when we get involved.
Exactly.
Yeah. Okay, great. All right, Sinead, next question. Well, this kind of goes back to what we were talking about earlier. Do you think it's a good time to try to settle existing workers' comp cases? Abe, what do you think?
Yeah, I mean, obviously everyone's seen what's going on with the economy. There's a lot of unemployment claims, stock market's down. There's a compounding effect of all of that. And when you have that going on and someone has an existing claim, people are off work due to the shelter at home requirements, settlements just make sense. It's a way to get tax-free income for security, peace of mind. So, I mean, you can reach out to the examiner, evaluate the settlement options, let them know about any changes in employment status. That will change the strategy on what type of settlement they can offer. But the lump sum settlements, those are the ones that will help during this time.
Okay.
And to add to that really quickly, and I think Abe mentioned it, just make sure that if there's any change in employment status, notify the examiner about it, because that might make it easier for them to pursue a compromise release instead of stipulation, or push for a settlement given the fact that they know they're not working and maybe they're applying for EDD, but that might take a month or 2 given how many applications they're getting. So it might be a good time for them to work up the file, make sure everything's being evaluated, and see if they can pursue a settlement with the employee himself or with his attorney if they're represented. I think, in my opinion, it always is a good time for a settlement, just making sure that the case is evaluated correctly and that all the potential exposures are taken into account. And a settlement at the right price is always right in my mind.
Mm-hmm. And I think, as we had said at the beginning, that people have a little more time. The adjusters have a little more time. The defense attorneys are not traveling to the Workers' Compensation Appeals Board. They're not waiting at the board, so they've got more time. And applicant attorneys are anxious to get their cases settled as well. And the employee is looking for a way to have, as Abe mentioned, to have some security. So I agree, all good things that are happening. Okay, next one, Sinead. Okay, this is a little bit longer question, but it starts out with, I have an open workers' comp claim. Is there anything I can do to keep the case moving to resolution and closure? So let's take a look at, there's a little bit of background information. Kai, I'll have you address this one and give us some of the background information about this claim.
Okay, so sure. So, so this employee has reached maximum medical improvement. This is a back injury. The employee is status post-back surgery. There are permanent work restrictions. The employer has conducted an interactive process, and they have determined that they don't have anything available based on the permanent work restrictions. There is a panel QME exam scheduled for April 15th. Of course, because of the shutdown, the doctor has postponed the exam. You know, going back to what Abe and Saul mentioned about settlement, I mean, this person is at maximum medical improvement. Right now, it's really a good time to try and settle rather than wait for that QME re-exam, which has been postponed, depending on whether or not the employee is represented or not. Reaching out to your adjuster to have that discussion. Ask the adjuster, okay, what is the settlement value if the case settled today? And understanding the dispute. Why is this employee seeking a QME exam? Is it because they disagree with the level of permanent disability, the MMI or maximum medical improvement status? Understanding those issues will give the adjuster a better idea of what that case may be worth. Let's say the panel QME is scheduled with a pain management doctor. Typically in comp, when you have a QME with a pain management, the level of permanent disability is almost always higher than an orthopedic. So taking that factor into account when they're trying to settle this case, for example, if this case is worth $50,000, does it make sense to offer this employee another $10,000 or $15,000 on top of it to shut it down now, rather than wait another 3 months, go to this pain management QME, but then at the end of the day, you're still at that same level, $75,000, $80,000. So those are the type of questions that you can discuss with the adjuster. What is the cost benefit of waiting? Can we settle it now? What is the value? What is the exposure if we wait? What is our chance of mitigating the exposure? And knowing all that will help as far as strategizing what the next best step is. I know some QMEs are doing telemedicine, but this is a back case, so it's probably not going to happen because, as Saul said, you can't do range of motion testing over the phone or over a video call. But if you have a case where it's a stress or psych, most QMEs will do that through a video call. But again, all parties have to agree on that telemedicine exam.
Yeah, which may be a challenge in itself. I mean, you've already have disputes, so is it likely that you're going to get agreement on that? I don't know. As Saul mentioned at the very beginning, it feels like every day there is something new, some new way of addressing issues, some regulation that's changing. It's all happening because we've not dealt with this kind of a pandemic issue before.
And I would be hesitant to do a QME appointment via telemedicine for a physical for a physical injury, just because if, like Kai mentioned, if you're a QME, there's some dispute over something, right? So it's really hard for the doctor to gauge whether the patient is really trying when he's doing range of motion or not via telemedicine. And those are important aspects that the doctor looks at when they're writing his report. Also, if you do telemedicine and there's a bunch of things that report that don't match up with the actual reporting you have from the primary treating physician, you're going to have to do an evaluation, you're going to do a supplemental, you might have to depose the doctor. It's only going to end up costing more money as opposed to just waiting the 2-3 months for the appointment that was rescheduled, in my opinion.
And if the employee is not represented, I think it's really important to have or request the adjuster reach out to that injured employee, have that discussion. Why are you requesting a QME? What are you disputing? Because it could be a matter of, I don't understand. I got all these forms in the mail, so I'm just completing the forms. And unfortunately, examiners, because of the volume they deal with on a day-to-day basis, they don't always reach out to the injured employee to explain what's going on. And so I think it's very important to have that discussion with your adjuster, or even schedule a conference call. If your employee is not represented, can we get a conference call so then you can explain to my employee what's going on and what a QME is. Maybe they don't know and they just fill out the form, or they think that they may get more money if they go to a QME, but that's not always the case. And if they're represented, depending on who the attorneys are, it may be a case that they can probably settle.
Oh, okay, good points. We use that term MMI, and we use that fairly frequently, maximum medical improvement. Abe, will you talk about what does MMI mean, and what is the significance of that?
Yeah, that's a tough one to explain in layman's terms. I've struggled with it before, just because it's a concept that it makes it sound like they're done treating, right? But it's actually this plateau where if you look at an injury like a timeline, and they had some status, this injured worker had some status before the injury, their pre-injury status. What the medical treatment is trying to do is try to get them back to that status, as close to it as possible. And when they reach that plateau, they call it maximum medical improvement. Now, there might be some type of impairment. They might not be at 100% where they were. Sometimes they are. Sometimes they're full duty. They're able to return back to work. But if not, then they'll assign a permanent disability and let everyone know what type of future medical that they'd be entitled to based on their injury. I don't know if anyone else has a different perspective on that, or a way to explain it, but that's the way I've been explaining it.
Yeah, I know, what I've, seen the explanation is, it's at the point where according to the doctor, he or she does not think this employee will get it significantly better within the next, the foreseeable future. And so they're at a point where they're plateau. So even if they get additional treatment, their condition will not change. So therefore, their condition can now be rateable, which is, now you go into the level of permanent disability. And I mean, this is probably too much for this session, but even though there is permanent disability, it does not mean that they cannot go back to their usual and customary job. I think that's a misconception. Sometimes you have an employee that has permanent restrictions, but has no permanent disability. And then you have cases where this employee is released to full duty, but the permanent disability can be 35, 40%, which is $60,000 or $70,000.
Yeah, and it can be confusing too with all the terminology. I remember one employer trying to explain whole person impairment to their employee, and English wasn't her first language, and she said that, "I'm sorry, but you're no longer a whole person." So there's a lot of ways to interpret the different words and the different terminologies and acronyms, but the bottom line is, you can leave it up to the experts for the terminology. If there's anything that you're not sure about, don't be shy about asking the adjuster to clarify, because there's a lot of different steps in the process, and a lot of them overlap and can be confusing.
Yeah.
I think one key aspect of maximum medical improvement is that once an employee reaches MMI, maximum medical improvement, they're no longer entitled to temporary disability. I think that's key because it cuts that exposure. And even if they have permanent work restrictions that you cannot accommodate, they're not entitled to be paid temporary disability for that time. So I think that's really important to know. I think from the employer's point of view, there's three things that you should pay attention to when somebody tells you MMI. One of them is permanent disability. What's the level of permanent disability? Number two is, are there any permanent work restrictions? Because that what makes you start the interactive process to determine whether you can bring them back or not. And third, is there any future medical care? And that one you might need to know just to make sure that, just so you know whether you have any potential future exposure on the case. if part of the future medical care says surgery, back surgery, you know that's a big potential exposure that might need to be considered if you're talking to the examiner about settlement or how to move forward with the case. So those three things I think are the ones that whatever else is going on, you should always ask for and know about the case.
Okay, good
Now,
comments.
especially if they're not represented, I think as an employer, you want to advocate for your injured worker. So once they reach that maximum medical improvement, and if they're still off work or they have permanent restrictions that you cannot accommodate, I recommend that you just reach out to the adjuster, or you can reach out to the injured worker as well, and just tell them you can apply for state disability benefits. Because once the TD is cut off, then EDD will pick up benefits because they're at that maximum medical improvement. And of course, EDD will offset the permanent disability advances, but that's something the adjuster can explain to the injured worker.
Okay, very good. All right, Sinead, let's go to our next question. I have an open workers' comp claim, and all the parties have recently agreed to a compromise and release settlement amount, but now it seems stuck in limbo. What can I do to get the claim closed? Kai, will you take this one?
Of course. So this one is actually, really simple. I mean, if parties have agreed on an amount, you just need to make sure that the settlement documents have been circulated for signatures. And once the signed documents are received by either the adjuster or the defense attorney, if it's litigated, they can go ahead and e-file those settlement documents with the WCAB. The board is not open for in-person hearings or in-person walkthroughs, but they are doing conference calls with the attorneys, and the judges are reviewing documents, settlement documents, and the turnaround time is pretty quick. What I've heard is they're getting settlement approved within 1 to 2 weeks. And I think part of it too, it's a small community. And so, the judges know that applicants' attorney's office are not open, so they're not getting new clients, and so they need revenue. And so just because of that, what they're doing is when they're getting these settlement documents, they're trying to get them through the system too, so that the injured employee gets his or her money, and then the applicant attorney is also getting his or her fees.
Okay, so you covered a lot of information that I thought maybe it's good to give some background about. So Abe, will you talk about what is the process? You'd mentioned before there's a timeline, and there's a timeline
Right.
for settlements as well. So what does that mean? They've signed it and now we have to get it approved. Talk about that.
Yeah, well, I mean, I think Kai hit on a lot of the major points, but obviously this is a legal process. So a lot of times there's going to be an application filed to get a case number, which they call an ADJ number. When you're getting toward the end of the claim, we're talking about settlements here. You're negotiating a settlement that could be with the injured worker, or if they're represented with the applicant attorney, you're getting those signatures. And as Kai mentioned, you're going to file those documents with the WCAB through the EAM system, which is an electronic adjudication management system. Those will get processed. Make sure that they're processed at the appropriate venue. The judge will review those documents, issue an order, and then the carrier will pay out the settlement and the attorney's fees.
Okay, very good.
I would like to comment on something that Kai mentioned, and I think it's very important. And she mentioned about fees, about applicant attorney fees. And I think this is key because the applicant attorney doesn't make any money on the case until a deposition is done and they get deposition fees, or until the case is settled and they get fees out of the settlement. So applicant attorneys currently are willing and able to settle cases because they still want revenue. They still want money coming into the law firm, right? So they'll do a lot to be able to have a CNR, a settlement signed, to have all the documents that are required to have them in front of the judge and approved. So they're willing and able to do that. And I think examiners and defense attorneys and you, the employer, needs to take advantage of that to push those cases towards settlement.
Now,
and Sharon, we have a pretty timely question that was just asked here on this exact subject. I think it's important we just attack this one pretty quick here. The question is, at what point in the process does the small business need to hire their own lawyer, and what can I expect the carrier to take care of? I think I think the answer really is pretty simple. The small business does not need to hire their own attorney. I don't think I've ever seen in my 22-year career where a business of any size has had to hire their own attorney, because that is all handled by the workers' compensation carrier itself. And California being, a no-fault state when it comes to workers' compensation. So that would all be taken care of by the insurance company and their defense attorney or attorneys. Does anybody have any other answer to that, or any knowledge of a situation where an independent attorney would be hired? I just can't think of one.
The way the question was asked, it makes me think that something has gone wrong before or currently is wrong. So they think that either the examiner, the defense attorney is not listening to them, they're not getting the responses they need. And that's what I think of when I see the question. One, I think never really, the employer should never really have their own
Right.
attorney or workers' comp. If there's a 132A issue, if there's an S&W issue, which are separate and not handled by the workers' comp carrier, then in those cases they should have an attorney if they need to defend the
right. And maybe just for let's see if we can can you give us a one sentence definition of a 132A? A very, very simple definition for the audience.
Discrimination.
There you go. Thank you. So it's bundled. Well, okay, that's perfect, because no, you have the workers' comp claim, but then the applicant attorney is then alleging discrimination as well.
And although it includes all forms of discrimination for filing a claim or for getting an attorney, usually it comes down to termination. So if you have terminated an employee, that's usually when we see 132As, but the labor code section, and that's the labor code number 132A, really applies to any type of discrimination against the employee for filing a claim.
Yeah, and we got to this point, I don't think that should be, should I get my own attorney? That should be, I should reach out to my agent, my claims advocate, whatever service you have, to have a teleconference or a conference call with the examiner, ask if the attorney can be on the call as well, so we can talk about the case, resolve whatever issues we have, and move the case forward. I think that's a better way to deal with that, as opposed to getting your attorney.
Okay.
Thank you.
So you mentioned that the applicant attorneys get paid for depositions. So Kai, will you talk about depositions? Are those going forward during this time, or what's happening in that arena?
Most depositions are being rescheduled, but there are some attorneys that will do a video deposition. Some may recommend a conference call deposition, which I don't recommend. I think if you need a depo in order to move forward, you do a video if you can't not do it in person, because you want to be able to see the injured worker, or you want the defense attorney to be able to see the injured worker, number one, verify the identity of that person, and also just to observe. I think it's very important when you do a depo, you always need to be able to observe that injured worker.
Okay, good. We also mentioned the workers' compensation appeals boards. There are, I don't even know the number, are there 13 boards throughout the state?
Sounds
something
right.
like that, 13 or 14, something like that. So are any of those open and doing business now?
The only board, my understanding, the only board that is closed is Eureka. All the other boards are open. They just can't have people coming into the court, but the judges are doing court calls or conference call. So the hearings are still taking place. Settlements are still being approved. You can either e-file the documents or you can mail. Of course, e-filing is a lot quicker, because when you mail in the documents, the clerk has to scan it. And for example, if it's a settlement document that you need the judge to look at and approve, if you e-file it, then the person that e-files the document can assign a task to the judge. Then the judge will have to look at that. Now, if you mail it in, the clerk has to scan it, and you're relying on the clerk to remember to set a task for that judge to look at those documents. If that clerk forgets, then it's just going to sit in the system and it's in limbo until somebody brings it up. Now, settlements for unrepresented injured worker, you just need to make sure, or not you, but the adjuster, they need to make sure that they have all the documents in order when they file it with the board to avoid any delays. Because what's going to happen is if the judge doesn't have all the documents to support the amount that is being settled, a lot of times they will set it for an adequacy hearing. So that's going to delay the process. And so that's why now that they hold off on the in-person walkthrough, so the judge can't have that, a conversation with the hearing rep or the defense attorney. You need to make sure that your adjuster has all the documents in place prior to submitting it. For represented cases, even if your injured employee is not at maximum medical improvement, you can still settle the case. I know one of the misconception is, well, my employee is not at maximum medical improvement, so I can't settle the case. And that's something that you'll probably hear from the adjuster, but that's not true. If it's litigated, there's a way they can get it through the board.
Any case can be settled if it's evaluated correctly and it's priced at the right amount, and all supporting documents go along with the settlement, with the actual CNR, the compromise and release, at any time. I think one key thing to remember is that each board is different, even though they're supposed to operate the same. They do differentiate a little bit in procedures sometimes. There's a huge difference. Well, there is a huge difference between the Northern California boards and the Southern California boards. When I was an examiner, I mostly handle Southern California file cases. I'm in San Diego. And whenever I got a Northern California file, I hated it because they tend to be stricter about requirements, what was needed for walkthroughs. They need to be usually stricter about whether somebody is MMI or not. But it can still be done. But just remember that the boards are different, the regions are different, and at the end of the day, just depend on your defense attorney and your examiner to tell you which board to use, which judge to go in front of, to make that case, to have a higher likelihood of having that case approved by a judge.
Okay, we have a question from the audience. Is there an outlet for advice on how to proceed as a business owner with filing out the legal forms that the employee's lawyer requests, especially when the insurance company does not offer advice? Who wants to take this one? Abe, you want to take a shot at this one?
I'd be curious to see what type of legal forms you're getting. I mean, as we mentioned, well, first off, a good resource if you're ever confused would be obviously Cal and us. We can take a look at the forms to see what it's asking. The carrier is indemnifying you from legal action. So the only thing I can think of is maybe the person is asking about subpoenas. We actually, our colleague who wasn't able to join today actually has a blog on how to handle subpoenas, which is a really frequent question we get. They look really scary. What documents do we need to produce? This employee's lawyer is asking about this. So if it's a subpoena, there's a specific set of instructions you can use that even if the insurance company doesn't advise you on it, they may not advise on what documents you can produce, but we have resources. Cal has resources. You can reach out if those are indeed the documents you're discussing or the legal forms you're being asked to complete. Other than that, can't really think of another one that the carrier wouldn't advise on or defend, as long as it's within the scope of workers' comp.
And the business owner shouldn't be really filling out any legal forms except for a subpoena. When you as a business owner get subpoenaed for records of the employee, that's the one you need to pay attention to because it's going directly to you. But all the other legal forms, you really shouldn't. When a claim happens and the claim is litigated, the carrier steps into the shoes of the employer. They become you when it comes to that case. So typically when you get any sort of legal form, legal correspondence, if it's addressed to you, your carrier would probably be CC'd on it. So just look at the end of the letter and see if it's any CC'd. If your carrier is CC'd, it means that they also have the letter and they more than likely will take care of it because they have to, because they step into your shoes. If by any chance you see anything that you are worried about, you really don't know, has a timeline, reach out to your examiner, whether email, phone, let them know, hey, I got this letter, I see you're CC'd on it, do I need to do anything about it? So that way the burden goes from you to them, for them to tell you if you need to act on it. But more than likely you don't, because like I said, they step into your shoes. They become you for that case.
Thank you.
Okay, great. Well, thank you all for joining us this morning. We will be sending the recording as well as the slide presentation with our answers. That'll be coming up before too long. Joe, I'm going to hand it back to you.
Yeah, no, I just want to thank our friends at ESM, the great panel that we had here today, and also thank you for the good questions that were asked by audience. And just a reminder to go on to either of our blogs, esminsight.com or mycalteam.com. And particularly from our last seminar, there were a lot of folks that wanted the link for the work from home exposures and strategy webinar materials, because in there's two different safety, well, there's one safety program that can be rolled out and editable forms as well. So there's really important documents for employers to take advantage of. So please do visit our resource centers on our sites. So thank you to everybody for your attendance today, and thank you to our panel. With that, I wish everybody a good rest of your Tuesday, April 14th. Take care and be safe out there.
Okay. Thanks, Joe.
Thanks, Joe.
Thank you.